step. Tell us when you will settle with these 41 persons which are mentioned in the report of the government.
So let me just tell you what the latest situation is. My instructions are, there is, as you have seen, an association. So there are some talks which are all with the association as of last week. And they are trying to work out some settlement, but the association of members, etc., obviously have to get the consent of all concerned. So essentially, I just said there is no problem. There are two ways of doing it. One is that possession is given, which has been offered to everybody. So that is one way of completing it. Now what has happened is after possession is given, there are two things. People are reluctant to take possession because then they are liable to pay charges in this grand minutiae ball, etc. That's one. The second thing is that there is a tripartite agreement or a bipartite agreement which has to be registered. Now this the head tell us about these 41 people why you could not settle. Tell us specifically about this, then we'll go case by case. You must have a look at this issued order because the order can't. No, because it's not on my part that there is anything. It's they are not coming forward to settle now. Therefore, we are calling upon you to show us specifically those 41 persons have been named. Keep aside other persons who are not traceable. We'll come to that later. Okay. So tell us what are the. So let's concentrate on these 41. Okay. So just please take up. There is a supplementary. I've dealt with this in a chart. So let us go to the chart of 41. There's something called a supplementary reply affidavit.
So we don't know who are 41 out of your chart.
No, they have numbered them, no? I've got just one thing which I wanted to tell. If we sit down, Lord, the plot has been given. The list which he gave to us, there is 332 persons. 103, what the state has done is out of the FIR. No? Is out of the FIR.
Right.
FIR is of 103 persons. List not of allotting. Given to UP SIDA first.
Let us go step by step.
No, not
deal with every investor. Now, have you checked up the affidavit filed by him?
Whether this is filed on 10th May affidavit.
On page 3, paragraph 6, they are saying
This counter.
Supplementary affidavit filed on 10th May.
Have you checked up the list of 41 whether they are the same persons?
Yes,
Your Lordship, we are on the 40 people. They
Please go to page.
haven't paid anything, neither the money nor the property, Your Lordship. They have not given anything. As per the settlement, they are saying that settlement has been arranged. Nothing has been given.
So that's wrong.
That's also, Your Lordship.
Anyway, so have your Lordship located my supplementary affidavit?
Yes, but we don't know that the same 41 persons.
But I have given a list for affidavit at annexure C, which begins at page 10. It is annexure R1 to this affidavit. Please go to page 10. Now I will take you through these. So you will see the list of 41 ends on page 13.
Ultimately, object was you must settle with them.
Of course, you have to make an effort to settle. So I have offered people in this 41. People have already entered into agreements, but they are not taking possession. I told you why they are not taking possession.
No.
Sorry,
We don't know that. You must tell us about each person, 41 person named by him, what efforts you have made and where the settlement, what is the reason for not having a settlement?
All right, I should indicate one thing. What I have indicated in the chart is a what point.
This is a case of cancellation for cancellation of bail.
This is not a case for cancellation. We've given 50 crores as willing to settle.
Just a chart. We don't know why matter could not be settled. Until we go to each and every investor. After you deal with 41, you tell us that. Tell us what efforts you have made, what was your offer, and why offer could not go through.
All right, then I will file I have given a chart over here.
That was the only object of granting bail, so that you settle with everybody.
But I have settled, brother.
Otherwise, let him go inside for some time, so that he'll realize the value of grant of bail. After coming out of the bail from jail, also he's not settling.
No, we have settled with 103 buyers.
There are more than 300.
So, can I just tell your Lordship, broadly speaking, what we are saying? First of all, Manoj, I'm taking the point which your Lordship has made, and I will go item by item and individual by individual and give you all the details in terms of correspondence and efforts. That's one part. And secondly, as I told you,
Tell your settlement, tell your client. Even in one case, we find that a neglect on your part to settle will cancel the bail. One case is sufficient to cancel the bail. You tell your client, explain to him.
ultimately, I will agree your Lordship's whole observation is more than any explanation which I can put.
Releasing on bail was to ensure that he settles.
No, I understand.
And what is the date of that order granting bail?
6th of November 2019.
Which are the other investors?
So he has given us the list. UP SIDA 332 people. Page 21. But if UP SIDA is over here, if they are here, let us go. We've entered into agreements. They are refusing to register. The Allahabad High Court has passed an order They are not registering the agreements. How can they not register the agreement? We have written to them.
That's a different thing.
So that's the only thing. You see, in this, people who are saying that they have not settled is because the document of settlement is signed, but registration is being declined. So we are saying we appoint a date and time, we go to that, and we have told UPSIDA that look, in whatever format you want, you please approve it. How can they refuse registration? Otherwise, I'll file a detailed document-wise, individual-wise particulars.
We have to use the supplementary reply on behalf of the petitioner. We are not satisfied with the stand taken by the petitioner that he has made a genuine effort to settle the dispute with all investors. In fact, from the order granting bail, order dated 6 November 2019 granting bail, it is apparent that the object was releasing the petitioner on bail will facilitate settlement of the claims. First off, firstly, we call upon the petitioner to file a detailed affidavit setting out the reasons why the petitioner could not settle the claim of 41 investors named in the status report filed by the respondent number 2 on 8 May 24. After we are satisfied that, after looking at the details submitted by the petitioner, if we are satisfied that all efforts have been made by the petitioner to settle with these 41 persons, we'll look into the claims of the other persons.
Very well.
Next paragraph. More than 4 years elapsed from the date of grant of bail. Therefore, we are putting the petitioner to notice that if we find that there is no genuine effort made, genuine and bona fide effort made by him to settle claim of even one investor, that will be a ground for cancellation of bail.
But may I just request that order? So I'm just.
Otherwise, order of the court becomes ridiculous.
Your lordship, sir, clear. No, what I'm suggesting to the court is your lordship may make that last sentence an oral observation.
No.
Put it into the order.
It has to be in writing. Otherwise,
But it's conveyed to the gentleman over here. I'm suggesting that otherwise, when it's in an order, etc., it becomes very problematic.
we grant time to the petitioner to do so till end of June. End of June.
Yes, very good. So, well, that's why I'll file my affidavit by
End of June. For considering the compliance made by the petitioner,
with respect to the 41.
yes, in terms of this order, this on 19 July.
I have people of association, may I also file an affidavit?
No, we'll first deal with 41.
Yes, let's see.
Then go to the other investors.
Just take them all, see 41.
First, let us see what he says, then we'll hear your response.
Yes,
May I just say one thing? 2.9 is a fresh application filed by me. Notice has to be.
Which is the fresh application?
2.9, IA 242.
But there are already 9 applications for cancellation of bail. Now we
Yeah, cancellation of bail.
Yeah, but that was 5 date replies. How many more?
Mine is the contempt application. In that they filed a reply. On the last day, my
What is it? Your
It's the same issue order.
No, it is not. I have taken possession law. Possession has been granted to me. First issue is that they took 6.1 lakhs for stamp duty. Now they think that we cannot shoot conveyance. Number one.
What is the contempt petition number?
That notice has been issued on the same issue.
2.8.
All right. So say that contempt petition number so and so shall be also heard on 19th of July. See, we are dealing with the issue of cancellation of bail.
Yes, sir.
There need not be multiplication of applications for cancellation of bail. We are dealing with holistic issue of all investors.
Adoption to the 17 will be taken up with the remain. Of 19.
See this. What is the ground for application for cancellation of bail?
not come up.
Therefore, he has to settle with all investors.
Yes, my lord.
We are examining the claim.
Yes, my lord.
Right.
Then my
I just renew my request.
Yes.
Before your lordship signs the order, please
No,
consider.
that has to be there.
No, but it
What,
has to be.
otherwise, it's a mockery of the proceeding.
It's not about, I'm just requesting your lordship may not keep that line regarding one person and all.
Unless we do that, your client will.
All right, very well, very well.
Item 3.
Yes.
Now let us see the report, compliance report.
Yes, ma'am.
Because I filed an IA on behalf of the IO and the sub-inspector. Now, Lords, may I just, your lordships have passed the order, the state has taken some action, Lords, an inquiry.
FIR have been registered.
I'm only praying, Lord, lordship will not foreclose if any observers.
When the witness deposits in the examination chief
Yes, Lord.
that the witness was threatened and whatever has been
Yes,
done,
Lord.
there is no re-examination made.
And the PP, Lords, I can't.
You are instructing the PP.
But the PP has to do it, and now she's retracting from that. Now she said that I made that statement because my lawyer told me that alleged against the police in the inquiry report. So she's not a witness that can be relied on.
This is the way inquiry is conducted. She is allowed to retract the statement made before the court.
Says it, my lords, herself.
Because this is the way police are conducting the inquiry. Let us see.
No, we have suspended them,
No.
and we have also.
Easy, right?
SIT.
Has the witness retracted her statement made before the court?
No, it is not before us.
Because in the IA, my lords, in my IA, which is
First, your lordship, may kindly just see, Lord, why action taken, which the state has taken pursuant to your lordship's order. First, let me just show, Lord, for the lord.
No, what is your I? Let us see that.
was IA 116851 for impediment.
Alright, where is that retraction?
And
So
page
it
30
was, then police are still playing the game.
Because there is no, I'm only saying, my lord, it's an unreliable witness.
Where is,
Your lordships are taking a statement to be the gospel truth in a
we
trial.
have to take it because we tell you, we have to take it because it is the statement of prosecution witness made in the examination chief.
Yes, my lords, but it is ultimately for the trial court whether to place reliance or not. The trial is still pending, whether the trial court relies upon it or not. It's a trial, it's not made on an affidavit.
We are not worried about it. We are worried about the which this lady is treated by the police.
Because she says it herself in the inquiry, not even now, PC 32.
That's right. So this is actually one more thing police have done. The inquiry she must have been again pressurized.
Because your lordships, my lords,
That's the reason, Lord,
the
we have
impression that you
to this right, Lord.
I have an FIR against me, I have disciplinary proceedings against
Then
me.
why are you intervening?
Because your lord, I'll be left with no remedy, my lord. One observation from your lordship, my lord, I have no remedy after that.
Now, because you have invited attention to this, now we'll make observation now.
That's my right.
That the role of the police still continues. Now, lady has already retracted her statement before the.
That's prejudging my rights that are there.
You're not allowed to withdraw your application, withdraw your lord, you have to say something.
With respect, my lord, your lordships can't take a citizen's right away, my lord.
We are
I have a
not
right, again, I have a right to fight for caution against the FIR.
Who has taken away that right?
This is pursuant to your lordship's orders. That's
Of course.
I have no remedy if I want to go to the High Court tomorrow, whatever punishment, it will say that your lordships have passed.
Now we'll order inquiry into this affair also. The lady has withdrawn her statement before the court.
Your lordships will do that. Just one second. Just, I'm not on that, Manoj, but I have certain rights after the FIR is registered, after inquiry is initiated, Manoj. As a citizen, same question arose in Andule, Manoj, before your lordships, whether your lordships can
We are telling you, we are not foreclosing that, but we are ordering further inquiry.
Lordship,
But which this inquiry is being conducted by the police.
Lordships may bear in mind that the trial is on. It is for the trial court to form an opinion whether she is a wholly reliable, wholly unreliable, or partly
You know
reliable.
what happens to normally appear for the other side. How the witnesses are being pressurized day and night.
My experience on the other side, Lordship,
So you'll have better experience to tell us about how police manipulate the witnesses.
this is the statement that is given. I am saying protect my rights, my lord. Lordship may not foreclose my rights.
Opportunity, Lord, we have formed an SIT, Lord. Now we have also suspended them. FIR is lodged, Lord.
Now please tell us who conducted this inquiry. Tell us.
Lord, it is being conducted, the evidence
No.
was also filed by the DGP.
Just see page number, this page number 22,
Yes, my lord.
starting from 22,
Yes, my lord.
and then who has submitted this report?
This is 22, DGP, Lord, just let me just.
No, who has conducted this inquiry? Who has recorded statement of witnesses that what she said before the court was false?
Or this. Or this is Office of Deputy Commissioner of Police.
Who has recorded the statement? You want to know who has recorded the statement of the witnesses?
Seems the additional deputy commissioner of police.
Yes,
Page 22.
So it was under the DGP, Lord, the DGP is monitoring this. The affidavit is also filed by the DGP
No,
here.
please tell us.
SIT is also being formed by
We
the
want to know who has recorded the statement of this woman and in whose presence. We want to know that.
That's why my lengthened answers are, Lord, this statement which your lordships have taken, not there in the FIR. It's made for the first time in court, my lord. This
It's not serious.
It's serious.
That weapon was given in the hand of the lady. She was told to try the weapon.
If it has happened, my lord, if there's an exaggeration on her part whether she did this or didn't do this. Now, because of that statement which is pending trial, my lord, I have an FIR against me and disciplinary proceedings against me, my lord. Both of them.
My God is being treated like this. So we want an explanation for you who has conducted the inquiry in which this statement is noted.
Lord, the additional SP is recording the statement, my Lord, along with the women police officer.
No, we just place it on record. Place an affidavit on record.
I can do that, Lord, but Lordship may at least just see, Lord, what your Lordship
That we see now.
and what, my Lord, I have done.
The remedy clear. So many this.
Mention is that my rights may not be.
I number 116852 of 2024. The applicant, police officer, is relying upon statement of the witness recorded in some inquiry.
In the disciplinary inquiry. Disciplinary stuff.
We direct the state to file an affidavit setting out the name of the officer who has recorded the statement of the witness, which is reflected in Annexure A2 to the application, and in whose presence the statement has been recorded. Full stop. Next paragraph. We have seen the affidavit of compliance filed on behalf of Director General of Police. Now, first information report has been registered and disciplinary inquiry has been initiated against the concerned officials.
To the suspension of suspended also.
It is pointed out that the concerned officials have been suspended.
And also an SIT is performed.
Needless to add that all defences of the accused shown in FIR number 327 of 24 remain open, and even the contentions of the different employees in the disciplinary inquiry, disciplinary proceedings also remains open. We direct affidavit in terms of the above shall be filed by the state by end of June, this on 15th of July.
No observation of your lordship's.
That we see now. First, we want to know.
In my,
We have protected your defenses.
I have no defensive, my lord, but everywhere your lordship's order will be cited, my lord, for my, only that no observation is prima facie.
We have not made any observation. They have said that this is what witness has said, inquiry has to be there.
My lord,
Yes.
two officers, two police who are female.
Therefore, we have said your defenses in FIR are open.
Yes.
Your defenses in disciplinary proceedings are kept.
Because the IU I can understand, but the two lady officers have also been suspended because they had nothing to do with it. There is no allegation against them also.
They can always challenge it. That's what we have said.
That's what we are wanting, my lord, that's all.
Yes.
And
All right.
Your Lordship also observed the SIT has also been.
That we'll see now first. Then we want.
I have placed it on the Lord.
Correct. We are not accepted. See, we are not accepted your affidavit as full compliance. We test that affidavit after knowing.
Then I will highlight that is not the problem.
After knowing that.
Indicate
Yes.
the
Back and forth.
Right.
Where is the report?
Is for the report had been placed by the Indore. We've not even supplied a copy. On the last occasion, what she did.
But who appears for the
Raju,
medical board's report?
yes, my colleague is there, but I'll hand over the copy.
Just show us that.
If I may have a copy as well.
Possible on two terms also we have said. Must explain.
A biopsy doesn't reveal any malignancy.
Yeah.
In summary on the next page, maybe references. The medical
Suggestive of immune
complex mediated NPGN. The allograft biopsy suggested this aforementioned problem may be due to a recurrence of the patient-related kidney disease or a new disease pneumovenous transplant.
Because just see earlier A also. Decline in the function of the transplanted kidney,
Yes,
the kidney is not functioning well.
Yes, but there has been a failure here.
Gluten sensitivity, the patient can have diarrhea.
So that's
This, he must get medical bail. Look at his condition. He is suffering from allograft dysfunction, which is failure of the transplanted kidney.
No, my lords, may kindly have a look, my lords. Kindly have a look, but they are suggesting a further diagnosis. Kindly have a look.
That will go on, but
let that treatment plan be there. Otherwise, a huge fraud, man. Kindly have a look at that.
in their custody.
Mr. Raju, just look at this. Look at the first report
Yes, my lords.
of the medical board. That allograft dysfunction and celiac disease. Now they have explained what is the meaning of that,
Yes, my lords.
right? In this fresh assessment, they have mentioned
But they have said he is ambulant, not stable in the first report, my lord. He is ambulant.
a person who has undergone kidney transplant. That kidney transplant is a failure. How can such person be
I'm not
continued?
saying it's a failure, my lord. Kindly have a look at the
No,
report.
just the first medical report, first medical board report, just submitted earlier.
Second renal transfer.
That's it. That's it. See under the heading renal transplant surgery, including internal medicine assessment dated 2nd March 24. See two phrases used. One is so presumptively as celiac disease, and secondly allograft dysfunction. Now in the latest report, they have mentioned what is the meaning of this.
Yes, they mentioned.
That's very important on the page.
He doesn't have, now he doesn't have celiac disease, my lord. Kindly look at allograft distinction.
All the celiac disease is not there, but the function of the transplanted kidney is not well. That's what they say.
Yes, but they say that treatment plan is to undergo, if he diagnosed and they say there's nothing serious, then what, my lord? So let him undergo these other diagnoses which they've suggested. But kindly therefore have a look at the treatment plan to continue current immunosuppressive therapy. Dooth is advised to get ANA, HCV, RNA, PCR, HBV, DNA, if they're possible. That's it. Does this undergoes that test that let him undergo those tests and may be reviewed after a week.
Medical bill in this.
Now, kindly look at the High Court order, page 5, my lord, direction given.
Right.
Now,
How long he is in custody?
He was arrested. He spent 4 months in custody in this case. In the earlier case, he was released on bail. He was taken in custody on 20th of April 23, and on 24th of August 23, he was given interim, which was finally concluded by dismissal. Then we came to your lordship protected him from surrender. And he's going 3 times a week. He's going to the
What is the stage of trial? The PMLA?
No, I understand, Your Lordship, 37 witnesses, 15,000 pages, charge is not yet framed.
15,000 pages of what?
Documents, sir. Relied upon documents are 15,000 at page 229 to
There are fraud, then large number of documents, larger the number of documents, my lord.
But at some stage, my relative will also have to take in sections. How many cases are they framing charge? Despite their best effort, they
Because
don't
the special court
Because the accused are not appearing in court.
It's a very interesting thing. They've got enough special courts created, not because these are also kindly, might not be recalled. Most of the conceptual parts, so they have the benefit of both the trials and both the records before them. But eventually, because what's happening in most cases is the further investigation keeps going on, and
In this case, my lord, in this case, the accused are not appearing in court. Some of them are absconding.
But they're granted bail by this court, sir. They're granted bail by this court. They're
All right, yes, Mr. Raju.
and that's the same law batches here, sir, which we argued in your lordship to reserve judgment.
But look at the nature of fraud, but a huge fraud. He may be granted my lords are inclined to grant him medical care, let it be there for 15 days, 20 days, and let it be reviewed after that.
Third learned senior counsel appearing for the petitioner and learned ASG Shiraju for the respondent. We have perused the reports of medical board. Two reports of the medical board, the last one being of 15th April 24. The first report indicates that the petitioner has undergone second renal transplant at Singapore. It is reported that the petitioner is diagnosed with kilogram dysfunction, which means decline in the function of the transplanted kidney. So, the second report indicates that the petitioner is on immunosuppressive therapy and further tests have been prescribed. To stop. Considering on conjoint reading of both the reports, we find that the petitioner is entitled to continuation of interim bail granted on medical grounds. For the time being, we continue the interim bail till 6th of September 24. In the first week of September, say 13th of September, the first week of September 24, the petitioner shall be taken before the medical board and fresh assessment of his health condition shall be made. List on 9th of September for considering the report.
He will cooperate with the trial.
It is that the petitioner shall continue. Petitioner shall cooperate with the trial court.
Your lordship is predicting till the next week.
13th September, we kept it on 9th. Yes.
Lordship, this is the after notice matter. And also in this matter, two of the coaches have been granted benefit of bail. In the case of present accused, exactly similar, Lordship.
Yes, what do you say, madam?
In this for different matters, he was director during 2011 to 13. He was the director of complaint between 11 to 13.
No, correct, but this is 409, 420, 468, claimed with 120B. Now, when he was arrested?
December 21.
7.
2 years, 3 months. This file is bound to take time.
So, time will take time.
Right. And charge sheet has been filed.
Yes,
sir.
There's nothing placed on record about his antecedents.
My lord, there is one more complaint against him.
Lordship, basically this one case.
That is 120/13.
What is that? 2013.
Yes, my lord. That is also an actual organ. Right.
Leave granted. The appellant has undergone carceration for a period of 2 years and 4 months. Charge sheet has been filed, except for old case of 2013. There are no other antecedents. The trial is likely to take long time. But the offences, section 409, 420, 467, 468, 471, and 120B of the General Code, as well as section 6 of the MP Protection of Interest of Depositors Act 2000. So therefore, the appellant is entitled to enlarge on date in the disposal of the case. For that purpose, the appellant shall be produced before the trial court within 1 week from today, The trial court shall enlarge the appellant on bail pending the trial on appropriate terms and conditions. Or it is accordingly allowed.
Item 6. But I would frustrate is like not a single witness deposed.
For the state. Who is appearing for the state?
I appear for the state respondent. I have received instruction today morning. I am yet to receive the complete paper book from the state.
Just 11 witnesses have been examined. Whether a single witness has deposed against him, you just go through the depositions here, annexed it.
But I am yet to receive the paper book from the state. I have received. My lords, may kindly grant 1 week time.
Yes. Call it. Appearing for the first respondent during the course of the day, list on Friday.
Grateful, dear. Great.
So which are the 19 cases against you?
But may I just draw your lordship's attention to this application, the joint inspection, joint.
No, we know that there is a FIR, cross FIR, and there is suspicion about the medical opinion. But one of the grounds is there are 19 cases against you.
I'll draw 10 cases have been discharged.
Correct, but which are the 19 cases?
But I'll just draw your lordship's attention to the additional addendum that I have filed, the joint investigation report. Take my lords to page 28.
Additional documents.
Yes, sir. I'll start from page 27 of this addendum.
So you must give a chart. What are the offences alleged? In which case you are discharged? What is the year of the offence? What is the stage of the trial?
Investigation report.
Give a chart. What are those 9 cases? Which cases are pending?
Page 59 of the SLP.
59 of the SLP. Let us see here.
No, I am a critical figure. I am subject to this. While all the cases are part of political rivalry.
So what are the offences in these cases?
But I have said
Because some of the cases are of 21, 22, 23.
and they are quite obviously it's a part of my might be for being a political figure. And if
All right, who is for the state? Have you got chart ready of the antecedents?
Because we only received the instructions yesterday, so kindly grant us some time so that we can file appropriate affidavit.
So we just see his FIR is first in point of time. And secondly, see the opinion. The first opinion is that there are bullet wounds, but just see page 81. Page 81 says that these are not the firearm injuries. You think we have to see the antecedents?
Sir, what information I have received is that there were total 19 cases, out of which in 10 cases he is discharged. There are currently 9 cases, serious FIRs that are pending.
What are those FIRs?
That
All right, we'll file you the particulars by Friday, list it on Friday.
please progress.
I can move.
My lord, I'm seeking a pass on behalf of state.
Passover. All right.
Obligatory.
This accused was detected by lordships. This was issued. No arrest complaint filed by the enforcement director of the appellate matter. The lordships have also reserved judgment.
Yes, correct. Your warrant was issued because petitioner did not appear.
That's right.
Yes, sir. Issue notice returnable on 29th of in connection with also arising out of ECR number so and so of date 1.
खुश रहो बेटा.
Item 10.
So this is the petition seeking anticipated bail.
You should have surrendered. 3 years back, your application for anticipated bail is rejected. This 302. You must surrender and apply for bail.
But your lordship, the similarly situated person whose role has been
Regular bail.
similar to the petitioner has been granted anticipated bail.
This is of wrongs. Will say that your application, you surrender, your application will be considered.
Expeditiously.
After having heard the learned counsel appearing for petitioner, we find that at this stage no case is made out for grant of arrest bail. Stop. Petition SLP is dismissed. If the petitioner surrenders for the investigating officer and applies for regular bail, we request the concerned court to take up the bail, to decide the bail application as expeditious as possible.
And he pleads.
Dismissed on merits and day.
These are the same case. This petition we have before your lordship, after being agreed with the order passed by the regular bail counsel. There is a report of manipulation that whereby my application for anticipatory bail was rejected.
Issue notice returnable on 29 July. In the meanwhile, petitioner shall not be arrested in connection with ECI number so and so published on page 1.
Okay.
Subject to condition that he shall regularly attend the special court.
Great. I can call.
Yes, Lordship. I am at the bar since 23rd of June.
Who accused has been granted bail.
Yes, Your Lordship. The main accused has been granted bail, Lordship.
Issue notice returnable on 22nd July. Liberty of standing counsel.
Okay.
Wait, please.
We have 7 months in custody, 7 out of 13.
Who accused granted bail?
Yes, 7 of them.
Issue notice returnable on 22nd July. Liberty of standing counsel.
Obliged.
Item 4. Yes, now today what is to be taken?
As far as the permission to travel abroad is concerned, my lord,
You know which one?
my lord, item 4. It has to be.
Lordship, pursuant to your Lordship's order on solid waste management.
Affidavits are far from being satisfactory.
Exactly, Your Lordship. These are the routine affidavits which are being.
Without understanding the seriousness of the situation,
Yes, Your Lordship.
all sorts of affidavits are filed. That they short for 3,000 tons per day. Please see who is appearing for GNCDD.
Fellows, I am appearing for the Municipal Corporation of Delhi. May I just explain why we have this shortage? May I just
We
explain?
don't want explanation. There is a shortage. What we are going for?
There is a shortage. We have built enhanced capacity. Where we build enhanced capacity, we are stuck in litigation in court.
That you don't know.
Fellows, I have got the details.
Who is appearing for Urban Development Department?
I beg to appear, my lords.
Please see your affidavit. Nothing.
Yes, madam.
No solution. No solution.
My lords, we have given the data of the, my lords, we have given how much money we have given, my lords.
There is no
And we have also given the status. If your lordships will kindly have the affidavit, my lords, your lordship
All
directed
affidavits
us.
have been there for 3 years. Nothing will happen. And every day, there will be addition of solid waste.
Yes, sir.
Because there are new constructions coming up. New people will come and occupy the premises. So somewhere we have to find out a solution to stop new constructions. That's the only way of doing it.
Would your lordships take it municipality wise from the affidavit of ministry,
No,
my
we
lords?
are not concerned with that. In the capital city, 3,000 tons of solid waste remain untreated every day. What is the solution to that?
This anything that has to be a wholesale solution. It can't be municipal.
Now, this urban development department says that nothing will happen for 3 years.
Yes.
June 27, they are saying, June 27. Expected timeline for completion, page 4 of the affidavit of the urban development. For 3 years, so madam, please tell us, what have you estimated how much will be the increase per day with the passage of time in generation of solid waste in Delhi? Some authority must apply its mind. Today it is 3,000. The kind of residential complexes and commercial complexes which are coming up, the solid waste will go on increasing.
So, my lord, if these are taken emergency measures and it should be done at
Now, all of you sit together and tell us which category of construction should be stopped till appropriate capacity is generated. Do tell us. Otherwise, today it is 3,000, by 27 it will be 6,000 per day.
That is why we have enhanced capacity.
But it is not functioning. Not functioning.
The reason why it's not functioning is because we are in court, my lords. We have been taken to court by a variety of organizations who are saying that this is a threat to the environment.
Now,
the very same waste
now,
energy
Madam, we'll grant you time to hold meeting. Otherwise, tell us which category of construction should be still adequate capacity to deal with solid waste is created. Somewhere we have to stop. Otherwise, and surprisingly, after passing such a strong order, no authority has ventured to make an exercise to find out how much will be the increase in future.
My lords, if your lordships see, I beg to appear for two of the authorities. We placed the affidavits. One is CAQM, the Commission, and the Ministry.
GNCTD, affidavit
Yes,
of
my lords.
This permanent solution has to be found. Otherwise, tell us which category of construction should be stopped in Delhi. We'll pass that drastic order.
My lords, I have placed the affidavit of Ministry of
your affidavit. Please see page 4. You say
Housing
that
and Urban Affairs, my lords.
Just
MCD will have to answer themselves.
they are not blaming you, but just see the situation. Today, 3,000 tons of solid waste remains untreated. Now, say that we'll be able to deal with 3,000 by June 27. By that time, it will be 5,000 or 6,000 per day.
So, my lords, if your lordship see the CAQM's report, the report indicates that this by 2027 the capacity will be there of legacy
3,000
and also it will be
3,000
sufficient for next 10 years.
3,473.
We are going by her affidavit.
Yes, well, in that affidavit, the enhanced capacity is going to be
27, June 27.
And it will be sufficient for the next 10 years, my lords.
But why are you saying no?
We are just hand over this capacity.
Go to page 3, paragraph 4.1 of her affidavit. Go to that. And gap is not 3,000. In that affidavit, gap is 3,800.
It is actually their affidavit.
3,800. Please see paragraph 4.1 of the affidavit filed by this authority, GNCTD. Please go to
Delhi government.
Delhi government. Go to that.
It is their stand on affidavit, and lordships, my humble submission is that this has to be done at emergency footing. This affidavit has been filed for like years altogether.
Now, madam, please read that affidavit.
My lords, I am also not appearing for GNCTD, my lords.
So who is appearing? Who's correct? So we'll go by these figures. And has any authority attempted to make estimate how much will be the increase of solid waste generation each day, per month?
Please see page 4 of this affidavit.
Please stop. In order to reduce gap of 300 TDP and stop dumping of MCD has proposed processing facility of 7,400. But please read the timeline. Expected timeline is June 27. Then second is December 27, December 25.
My lord, this is my submission, my lord, that when this augmented capacity comes in, it becomes 15,473.
But when, what year?
I'll just give you the timeline.
We are going by the separate of Delhi government.
The basis of this information is just expanded here.
Show us a statement. Show us in one sentence answer. Today shortfall is 3,008. Two questions we are putting. 3,800 tons per day is untreated sewage, untreated waste, solid waste created in the city of Delhi.
Yes.
Have you taken estimate how far it will increase? Then number one, when there will be a facility set up to process 3,800 tons per day. When?
My lords, we have 4 such facilities.
When? You want answer to this?
Underway, my lord. This is my.
When it will happen? When actually there will be capacity to deal with 3,000? Madam, you are not answering a simple question.
My lords, it is already underway. That is my point.
When it will come into existence, when the processing of 3,800 will start? Please tell us that date.
My lords, per my table and per instruction.
We don't want to hear for anything. Please tell us the date. Please tell us the date. Madam, otherwise someone who is the highest officer of this corporation? Will somebody? We are asking a simple question. We expect a simple answer. When you will develop capacity to deal with 3,800 tons of solid waste every day? Please tell us the date. As simple as that.
27, my lord.
So 3 years. How much will be the solid waste generated? It won't remain at 3,800.
No, my lords, we have planned for that enhanced capacity, my lords. That is why we will do 15,000.
Madam, please tell us. So therefore, for till 27, every to deal with 3,800. Very sorry state of affairs. It's a capital city. And you are saying that 2027 they will create the capacity.
May I just say one thing? There are cases which we have been doing before, my lords, where we have sought to increase capacity, but we have been taken to court before, my lords.
We are least concerned with that ultimately.
But my lords, how do we increase capacity when 4 major plants are stuck in litigation?
Develop one more plant.
We have addressed the solution. Because even last time when there was crop burning, we went after the states, nothing happened. Now Ministry of Housing and Urban Affairs, for which Ms. Bhati appears.
Yes, that's nobody understands.
About the capital, we can't.
You are worried about this. What the whole world will say? In capital city of India, 3,800 tons of solid waste being untreated every day as of 2024. What will happen in 2025? What will happen in 2000?
Lordships, there is more in Gurugram, Faridabad, Ghaziabad, Alwar.
Let us deal with the issue of Delhi.
It's Delhi, Lordship. So the union, I would suggest the union should sit with all the states.
But of Union of India will ask the secretary to hold a meeting.
Yes, Your Lordships, with all the stakeholders and give an expedited time.
Concerned department of India.
Ministry of Housing and Urban Affairs, they filed an affidavit. I don't know whether it's before you.
It's not there.
They have not filed.
We have got extra copies, my lords. My colleague is carrying extra copies if your lordships would like to see. We actually held a meeting with all of these municipal corporations, which includes the Delhi corporations and the adjoining NCR also, my lord. So,
now you hold a meeting and tell us what should be the preventive method to ensure that this 3,800 does not increase. What methods you are going to adopt? You means all the authorities.
yes, the corporations will have to.
The Lordships, they have given an affidavit for all the NCR areas. Tell them to file a detailed plan with timelines and expedite the process.
So now we are concerned, this 3,800 in which area?
This is Delhi, Your Lordship. But in their affidavit, Your Lordships could see they have given.
Whose affidavit?
It is the minute which was just handed over by for the union. Your Lordships, if Your Lordship sees the. affidavit of Ministry of.
Let's say, let us see now. Gurugram. We'll start with Delhi cantonment, but there's no problem. 60
Yes,
is
Your
the
Lordship.
generation.
From in that page.
So, my lord, if your lordships will first see Roman 4 also.
No, madam, just see Gurugram.
Yes,
The best generation for the ULB is 1200 tons per day.
Yes,
The
Your
current processing capacity is 150, only 150.
That's right.
Fine, actually.
Then,
Faridabad, Your Lordship.
you use the correct word, horrifying.
Please also see construction and demolition waste
Right.
of Gurugram.
That's right.
Lordship, please see Faridabad at page 7.
Everywhere there's a
1000 TPD and current processing capacity 240. Then there is Ghaziabad.
everywhere the situation is horrible.
That's the
Ghaziabad is not, my lord. Ghaziabad is generation is 1600, but processing capacity is 2000.
No, just see Gurugram, then Faridabad.
Gurugram and Faridabad is my lord's.
Greater Noida at page 9. 350 TPD and
Right.
around 130 TPD.
Alwar is all right, Ghaziabad is all right.
Yes.
Then
Greater
Noida.
Noida, page 9. And as your lordship stated, this is the situation today. It's going to increase every day.
And nobody is bothered to make even an estimate of that.
Exactly.
That how worse situation is going to be. Nobody is bothered about it.
Let them treat this as an emergency, your lordship.
My lords may direct us, my lords. We will hold because we are giving funds to them. If your lordships will have Roman 4, there is a union government's national clean air program, my lords, in which 131 cities are getting huge amounts of funds, which includes all of the Delhi and NCR municipalities.
We'll pass an order after that some kind of new construction has to be stopped, because unless that is done, the quantum of generation of solid waste will not reduce. Because today, 3,800 today. That's the situation.
Well, that is why we have planned this in a staggered manner. This
Planning is not
already
planning is of no use, because today for 3 years you have no solution. You are saying in June we'll have capacity.
No, my lords. It is already underway, but the capacity has been enhanced. That is why I'm saying we have this in mind, where we will arrive at 15,000 metric tons. No, my lords. In a staggered fashion.
We ask you a simple question.
Yes.
When you will develop the capacity to treat 3,800 of metric tons? Which month?
We already have this capacity.
But it is not.
That's why I wanted to hand over to you with the capacity.
So should we record your statement that this is false? Our simple question is, record shows that 3,800 metric tons of solid waste is untreated because there is no capacity to treat that. Is that statement correct?
May I just hand this over?
Answer yes or no. Is that no? Answer our question. We are asking a very simple question. We expect a very simple answer only.
It is not correct.
Not correct. So according to you, are you making a statement that every single ton of solid waste generated in city of Delhi is being treated in accordance with the rules?
There is a shortfall.
So what is that shortfall?
There is shortfall.
According to us, what is that shortfall? How much is the quantity of solid waste you are not able to treat every day? Tell us that figure. If 3,800 is wrong.
My lord, may I just hand this over? Please
allow
me this, my lord.
Sorry, tell us
Please
orally.
allow me this.
Madam, it is as simple as this. You say that the figure of 3,800 tons is incorrect. So what is the correct figure according to you?
May I just explain this? May I just explain myself?
Anyway,
Now, we have,
on the commission.
my lord, we have a plant in Narela, Bhavana.
Simple question. According to you, how much is the solid waste which is not being treated every day? Please answer a simple question.
There is a gap.
What is that gap you want to know according to you? That's the question we are asking you repeatedly.
But that's not my affidavit, madam. That is not my affidavit. We are not being able to find anything. We'd like to hand this over. This
Please
is my
ask,
affidavit.
make a instruction, whosoever instructing you, what is that gap? Tell us.
But if that's an income statement.
All it, let her take instruction.
Domestic urban affairs, they also say 3,000.
Instructions, let her take instruction just now. How much is that gap? Tell us. Ask your officers.
But should we just see the union affidavit? See.
All right, madam, we will pass it over. At the end of this, you must make a statement. how much is this
Very
money
good.
base which is untreated
Very
today. If it is not 3,800, tell us what is the quantity. And then we'll pass comprehensive order dealing with the others also.
I'm grateful.
Right.
I'm grateful.
And tell your officers, we want simple answers to simple
Yes,
questions.
they're here.
Please tell your officers.
Thank you.
This is actually very vital issue for the capital city. This is no politics involved in this. Yes. Pass on.
Item 1 already, 14 was not called out.
Yes. What is the item 1?
1 is 134634. I.
1 minute. We'll go one by
It
one.
cannot take long.
So, SG, you must also look into this. Sorry, state of capital city and areas around the Delhi. What kind of scenario is this? And what signal we are giving to the entire world? We talk about development. We talk about environment. What signal we are giving? And this is not a
Yes, with my colleague.
this is this issue.
It should. Then I don't think that is involved.
And MCD is not able to answer our questions today. Simple questions we are posing, no affidavit by MCD. So, Government of India must look into it. We are going to pass that on.
It must be. They must.
Which is the IIT.
Good. IAS 134634.
Right.
But I have a better suggestion there. Please come to page 15. So under section 146 and 147 of Motor Vehicles Act, so it is compulsory to have a third party insurance.
Right, correct.
Right, so your lordships were not concerned about the PUC, the Pollution Under Control Certificate.
Yes.
And page 15 is that part.
What is the prayer in the application?
The prayer is designed as oral ignorant point. Right. So what your lordships will see is unless there is a PUC, third party insurance will not be given by the insurance companies.
Right.
Now the resultant effect is that for lack of PUC, there are no third party insurance. Meaning thereby, well, it doesn't take
that direction issued by this court.
Page 15, that's what I
Page number
15. There are 3 columns your lordship could find. First is the question your lordship were considering.
Page 15 is something different.
But it would look like
chart. I know. There is the order which puts restraints on each.
Then let's look at the chart. This is the chart. But bottom 2.1, ensure 100% compliance with linking annual vehicle insurance with PUC certificate. So then the government's response. While linkage of renewal of insurance with PUC certificate may be desirable, it may be noted that vehicle insurance renewal is an annual feature, whereas the periodicity of PUC norms for any vehicle should be at shorter intervals. So it is either 3 months or 6 months. It has been observed with serious concern that coverage of third-party insurance for motor vehicle is very low at this stage. Not only 55% vehicles are covered by
certificate. That would not come in the way of seeking
council has filed this IA, which refers to order of this court dated 10th August 2017, passed on the basis of EPCA report number 73. The order of the court records that 100% compliance shall be ensured by linking annual vehicle insurance with PUC certificates. It is pointed out by the SG appearing for General Insurance Council that in view of this direction, in direction large number of vehicles,
55%, that's our
of the vehicles are not taking third-party insurance. So therefore, in the event of accident, the claimants are finding it difficult to get compensation. First off. Next, on the prima facie, we are of the view that a right balance will have to be struck for ensuring that vehicle remain compliant with PUC norms, but at the same time, all vehicles must have third-party insurance.
That's a mandate of section 146, 147. It's mandatory.
Otherwise, it's an offense also not to have insurance.
So otherwise, what happens? Right. Today I have the PUC. I go get the insurance.
That's right.
Insurance would be for 1 year, but the PUC certificate requires renewal after 6 months. So I'll not renew it. So it doesn't serve the purpose. The linkage doesn't serve the object.
We permit amicus and learned SG to come out with solution so that appropriate modification can be made to the order dated 10th August 17. This application shall be listed on 15 July. We request learned amicus and learned SG to give suggestions in writing before the next date.
Second, please. Great.
And for other issue regarding, we'll pass it over.
Great.
My lord, there is one intervention application as far as ammunition is concerned, which is 2385.
We deal with that. We deal with that. Pass over.
Maloj, would you inform your lordships, my lords, that these data has been given after collecting from everyone. We had a meeting with all of these corporations, my lords. That is in our affidavit we have stated. But anyways, let my colleague get the instructions.
Yes.
My lords, I was muted, my lords, for too long. My lords, I am in item 14, sub item 3, my lords. It's also a very short matter, my lords. My matters perhaps already covered by the order of 30th of 21.
We are taking one by one. So just wait. Let these issues be over.
Very well, Lord. Very well. I apologize.
What is like, Lords 15.
Who is appearing for the petitioner? You have given that.
Lords, I am appearing for the petitioner. 15.1, Lords.
But who is appearing for the bank?
Lords, I am appearing for the bank.
No, who is appearing for the? So what condition should we impose? You tell us.
Lords, they have moved an application for permission to travel abroad temporarily. Lords. I have already got the instructions that the orders will be completed.
Yeah, because just see paragraph 3 of their application. Of the affidavit reads thus. Notwithstanding interim relief granted in the special leave petition, we permit the first respondent, Shri Vikas Agarwal, to undertaking traveling in terms of paragraph 3 reproduced above, subject to condition that Agarwal will file an affidavit, file an undertaking on oath in this court to return to India by 27th of June 24.
That's like this.
Application is accordingly disposed of.
Because we just request that, as far as they are concerned, your lordships may vary the status quo order to that extent.
No, we are saying notwithstanding that order, we are permitted.
All right, grateful. But they must now send an intimation, and I've got a, to whom? Yes, so they have to send an intimation to the Bureau of Investigation and the Secretary, Ministry of Home Affairs. I've got a draft, I'll just give you the points.
No. Intimation to be given to which authority? You will incorporate in the order.
Yeah, so that's exactly why I got this statement here. Give it to the other.
There is enough of time. It is required when there is a lesser time.
No, any case,
No, I'll just, this is, please just see clauses, see clause 3. The Bank of Baroda was the petitioner here before your lordship be directed to apprise and inform the Union of India through the Secretary, Ministry of Home Affairs. They are respondents here before this court, but they are not appearing because they are not affected. And the Bureau of Immigration. You don't want to land up at the airport and show your lordship's order, and those people have something on the computer which prevents it. So this is necessary, my lord.
It could be
3 and 4.
we direct the registry to forward a copy of this order to the Secretary of Ministry of Home Affairs and Bureau of Immigration. We direct the petitioner, Bank of Baroda, to forward copy of this order to both the authorities. First up, the said authority shall ensure that the first respondent is permitted to travel abroad in terms of itinerary, which is reflected in this order.
Grateful. And undertaking within 3 days,
Taking to be filed within 1 week.
well, within 1 week. Yes, well, sorry, the second respondent also, after he comes back, the second respondent has given an undertaking with a separate affidavit that he will leave only after his brother returns.
Let's see now first, let him
that is in June, Manoj. The dates are 15th July, then all right, very well. Because he is leaving, then your lordship may leave.
Who is applying for respondent but 10? So are you carrying on construction?
No, they're not involved in construction. I was wanting to tell you.
That's what I want. So then let me point out how they're doing it. No, permit me that.
No, I'll answer the Lordship asked me a question. Let me complete the answer. There is a company called Spenta Constructions. They've not been made a party for best reasons known to them. They make them a party for the NCLT.
So according to you, who is carrying on construction?
Spenta, Sun City Private Limited. These very petitioners have made them a party in proceedings before the NCLT.
Yes. Now let me explain to your lordship why, according to me, IDBI is carrying on the construction.
No, they can't, Manoj.
So please permit me to listen before I
have made the CMD.
They have filed a contempt against the CMD saying IDBI is carrying on. We have no role to play. So let me point out to your lordship if you permit me. Now, my lord, my case is as follows. This property, no, since your lordship asked me,
I just request this, Manoj, let that party be made. Take it here.
Lord, I will be able to satisfy. They can be made a party.
Just 1 second. You are alleging that respondent but 10 is carrying on.
Yes, and I is controlling the entire construction.
Which is totally incorrect.
So then let me explain. Well, learned friend, don't mind.
Well, they are a debenture trusteeship company. Well, there's no question of us carrying on.
I don't know why they're not letting me argue the point. Now, the point is like this. Penta was given construction rights. A debenture trust deed was created in favor of, they are the debenture trustees, raising money for that construction. Land is mortgaged to them for 525 crores, they mortgage, when it was sold earlier for 123 crores. And my lord, now let me please place some terms of the debenture trust deed to show how they are fully in control of the construction. For that, would your lordship kindly come to my additional affidavit, which was filed, my lord, on 7th December 22, the additional document. I'll just show a few clauses from.
No, then we will take affidavit from undertaking from them.
Yes.
That they are no way involved in carrying out construction.
Yes.
And they have not authorized this company to carry out construction.
Yes. In case, in any event, my reply to record to the contempt, I've stated I'm not concerned at all, with either disbursing any monies, with either allotment of it. Nothing,
You are heading for whom?
Malad, I am agreeing in the contempt petition. They have made the Malad the CM.
We are concerned with this.
Yes, so I am Malad the CEO. So for that 16.1, they have filed the contempt against me. And I filed the reply, Malad, I am not concerned.
Dealing with contempt, we are dealing with this.
Yes.
003.
Now, let me show to your lordship why I say they are carrying on the concern.
Therefore, he will record his statement and ask him to file undertaking.
But I want to satisfy your lordship, sir, yes. But his point is, he knows who's carrying on construction. He doesn't want to make him a party.
Keep this pending or come with affidavit.
Yes.
That they are not carrying on construction.
And that they have no role in the construction. Now he's adding things. Please.
Just 1 second.
Yes, yes.
Also say that you are not authorizing this Penta Sunset.
No, he can't.
To carry out.
That's the alternative. Definitely. There's no question of that right away for your lordship. If I can answer that right away.
He gives the statement on oath, then what is the problem?
No, I have no problem. But I'm just trying to say that this statement is being made here is an incorrect statement from the record.
He's taking the risk.
No, let him take the risk.
In IA number 225003, Learned Senior Counsel appearing for respondent number 10.
Lordship's first notice contention that I'm carrying on construction.
So that's his application.
My application says so.
It's that respondent number 10, write down the name of respondent number 10, is not carrying on construction on the subject land. And in fact, Penta Sun City Private Limited is carrying on construction.
And they are not made a party. Without any role of the respondent, sorry.
We direct the 10th respondent to file we direct computer officer of 10th respondent to file a statement on board stating that the 10th respondent is not carrying on construction on the subject land and that the 10th respondent has not authorized or permitted any other entity including Penta Sun City Private Limited to carry on construction on the subject land.
Yes, I'm did
Learned Senior Counsel appearing for the appellant still insists that it is at the behest of 10th respondent that construction is being carried out. However, that issue can be gone into only after affidavit in aforesaid terms is filed by the 10th respondent. We grant time of 3 weeks to the 10th respondent to file the affidavit. List on 15th of July. This application on 15th.
Yes. Would your lordship then dispose of the contempt? Because we have not seen a.
No, I am opposing it.
No, if the 10th respondent filed the
only I is listed.
Now, so we are not in lordship, they gave a date so that it is IS bigger date. And my lord, of course, the earlier interim order continued. Which your lordship has granted that. Yes, yes.
What date please? Wait.
Who is for the respondent? I applied under 142. Now, who is for the respondent? Have you seen the application?
Lordship, I have gone through the affidavit filed by them. We also took instruction from the petitioners. The 14 Sridhan items which are mentioned, out of which 4 are with the petitioner. That is the correct fact. 4, but not remaining are with the respondent.
Now, this application is by the wife.
Yes,
wife.
Lord. It is by the wife.
Husband.
I am both, yes. Husband is online, is available.
Now, please go to paragraph number 2 of this. The 12 lakh, 15 lakhs, forget about it.
Yes, sir.
On page 3, now the petitioner wife says that these are items are with the husband.
That's right. Now, on 3, find counter to this.
Where is that counter?
That's on the record minutes. That's on record minutes. I have downloaded from the website only. Therefore, I can see it's on record, taken on record.
No, what do you say about this?
So, Manus, we have para 9. On the counter para 9, Manus, we have stated this. Para 9. So, this is what 4 items are with the wife. Rest of the items are with the husband.
With the husband.
And then he says, Manus, that para 12.
Car also is Stickle?
Activa, it's very Activa, scooter.
So therefore, according to you,
there are 12 Manus is the
no, correct. So out of 14, how many articles are in possession of the husband?
Manus 1, 2, 3, 4, 5, 6, 7.
No. So 4 are in possession of the wife. And rest are in your possession.
Yes.
Is he willing to return these articles?
No, he states Manos and para 12 Manos. I could not understand whether it's been. I mean, I tried to take proper instructions from him. Like para 12 may be saying Manos. This is what he says.
So then he says 10 lakhs extra is built.
Then he says that with regard to Sridhan being shot by the petitioner, the jewellery the petitioner got from her family are in her possession.
To return items mentioned in paragraph 9 of the parent reply.
So that's it.
So you have to return only 4.
4. That's what he says.
No, but what does he say about whether the other articles constitute the Sridhan?
He explains my notes at the bottom of the table, para 9. He explains that with regard to the items mentioned above, most of the items are in articles belonging to husbands or which given to the petitioner by the family of the answering respondent. As the answering respondent is unwilling to return the same, saying over and above the settlement amount. It is called, that's what he says.
Yes,
Lordship, those were the items gifted to the petitioner in marriage or during that period of when she was staying there. That is the Sridhan, whichever gifts given to the wife.
Today, we are prepared to exercise power under 142.
And Lordship, one more aspect I want to bring Lordship's notice is that one aspect only.
Yes.
That during mediation, the household articles which were gifted in marriage by the mother of the petitioners, respondents were agreed to return. Household articles like furniture.
Instructions from your client. What we are proposing is, we'll say that husband will pay you 15 lakhs in installments, and these 4 items which are mentioned in paragraph, this paragraph number 9. If your client is happy with that, we'll pass order resolving the marriage.
So petitioner is there.
Requires consent as per amount is
I'm just informing my lord.
right. Petitioner must be willing.
Sorry, respondent.
Wife must be willing. Just talk to her.
Respondent is there also there online. She is also there. Both are there.
Mr. Patil, talk to her.
Yes, Lordship, I had taken instructions.
This is the only solution. Otherwise, there is no other solution.
Yeah, Lordship, the item which are with the petitioner wife, let that be matter could be over on that, and that would be the solution. Anything from husband won't come, and I also told her that let you be satisfied with the items which are already with you.
Correct. And 4 items he is willing to return.
So it is already with her.
4 items.
He says that he is willing to.
No, it is written otherwise.
Already returned.
No, it is written otherwise. Other articles in the custody of wife needs of return to husband. That
we will not claim that 4 items.
Yes. All right.
Rituraj, court is directing 15 lakhs rupees.
Just talk to him. How much? We are passing that order in any case.
Yes.
How much time he wants to pay? That much should tell us. Talk to him. We'll pass over the matter. Only because nothing is exchanged now. Only his wife must be paid 15 lakhs.
Yes, Lord. That could be the assumption. That could be the solution.
We don't want his consent, but we want to give him reasonable time.
Yes, Lord. Lordship may give reasonable.
I think maybe.
Please. Well, this is a short issue. I think all expansion projects across the
Now, what is the fare you are seeking in by of entering the gates?
Well, the interim is for stay of the OMs. The OMs are visibly
Which for the state
completely contrary to the notification. The notification mandates public consultation.
Manoj, I beg to appear, Manoj, we have filed a detailed counter affidavit. In fact, one of the OM was only for a period of 6 months, and that was a special dispensation.
Stay is very drastic. No, they will hear the matter because granting stay of is very drastic.
As far as public consultation is concerned, it's a mandatory requirement. There are 3 judgments of the lordship.
But will be decided
all of them, the same
Public
issue.
consultation is happening, Malaj. This is only for expansion up to 40%.
Expansion is required.
The statutory appeal shall be treated as admitted for hearing and listed for hearing on Thursday, 29th August 24.
Well, a little earlier, because it affects all projects across. It's a non-adversarial matter.
Yes.
Not personally affected.
So it is adversarial, Malaj. It will bring a grinding halt to the infrastructure projects.
Can't be against the environment.
It has to be a balance, my lords. I'm grateful.
Section 37.
Great.
Well, Ajay, my lords, this is Gayatri Balasamy.
Correct.
The questions are similar to that because he has modified the award under 37.
That's it. Therefore, with 50, grant leave and keep it pending. In which case it is referred, that's order also here. That's
So Gayatri Balasamy versus Mrs. ISD Novosoft Technologies.
Delay in refiling is condoned. Leave granted to be posted after reference made by order dated 20th February 24 in petition for special leave to appeal number 1536-1533-21 is answered.
Just one thing, kindly pass over.
All right, pass over.
21. But this is a statutory appeal, and this is the textbook instance. I'm so sorry.
9. Remember, these are from 9. Things decided in the second episode.
21 days.
Okay. Actually, this will have to go back. Nothing is decided.
Exactly the point. We are here only for remand for the simple reason that additional documents have not been considered.
And your findings are not given on some of the issues.
Not just the regulations of 2001 have been considered when this is started 2016.
Delay control. This prima facie it appears to us that considering the nature of the impugned judgment, this please show us that you have deposited 50% of the decretal amount. Where is that? Finding is to the contrary.
I will policy based 20. Order. Button CM.
What was the degree?
Degree
Was how much was the amount of degree?
Amount of degree malod is the decretal amount of the 50% is what is malod and this was confirmed malod on that demand. And our policy based
Deposited 10%. That's all right. Issue notice. As a statement is made by learned counsel appearing for the petitioner that in terms of interim order dated 22nd November 2019 passed by the High Court, the petitioner has deposited 50% of the decretal amount. We direct the petitioner to file a specific affidavit in that behalf, giving all particulars within a period of 4 weeks from today. The notice is made returnable 29 July. No, what is the stage in execution?
Last date of hearing was the 4th of May, my lord.
Yeah. As the petitioner, as the learned counsel and petitioner has made a statement that the petitioner has deposited 50% of decretal amount, we direct that execution proceedings for executed decree shall not proceed.
Your I have been deprived of the right to arbitrate. I am a
Society and members must go together. And if you see the clauses,
yes.
clause 35.2, 35.1, yes. Technically, names of all the members are shown.
Because all the members not only shown, but they also individually signatories.
35.2.
Yes, 35.2, I have answered that. 35.2 will apply in a situation where the members and a majority of the members want to arbitrate over a particular issue.
So what is the stand of the society?
The stand of the society, we've said that contributing to the developer.
Everything will be heard at that time.
But the jurisdiction, because jurisdiction will be the DRT, because these are not jurisdictional facts.
You can always argue that application was not maintainable under section 95. You can argue that. That's what the NCLT both the groups are fighting. And both of you are members of the bar.
No, I am not. Because the complainants are not the members of the Because please appreciate that the finding of the Bar Council of Uttar Pradesh has been set aside without any material.
If we go to the basic complaint, basic misconduct alleged, that is subject matter of pending proceedings.
No, but because I also informed the Bar Council of Uttar Pradesh that he has court signatures to.
No, then you should have firstly filed a police complaint and then separate proceeding for
Because the person whose signatures were pulled, he filed an affidavit saying that I did not sign any of them.
After having perused the order of disciplinary committee of Bar Council of India, we find no error.
Your lordship can consider it, holding it back to
No,
the side.
not at all. Just clause F, the guarantee is for benefit of disposable one bank also.
Certainly, Vinod, but it is still a bilateral contract.
Maybe
Not invoked by the person in whose favor the guarantee is issued.
it is for benefit of the trust has taken guarantee for benefit of even bank, disposable one bank.
Certainly.
Clause I am page 28.
I'm with you, Lord. I know it is for the benefit, certainly. But it's still a bilateral contract. And because there is no event because of default, the matter actually is covered by a judgment which has been
There is a default. What else it is?
With utmost respect,
On a guarantor.
please have a look at the terms of the contract, which have been analyzed in the identical
And section 7 has been admitted.
Section 7, yes, that was against the borrower. So when the borrower is concerned, Section 7 is admitted, resolved, money is paid, money is received. This is guarantor. Because the guarantor, the invocation firstly is not by the party in whose favor the guarantee has been issued. The Section 7 is not been filed by that party. Against whom?
This IDBI bank has filed section 7. The guarantee is for the benefit of IDBI.
Most certainly. But the invocation is not by trusteeship, neither in the Section 7 application.
Even IDBI can invoke.
Thirdly, third point is that there's a procedure prescribed under the